Madam, I think she said that 17. Just today I have been like, kindly pass over the matter for 2 weeks.
On Tuesdays and Thursdays, I'm sorry, we are not adjourning any matters. Let the matter reach, then you make your prayer.
Lord, I have a similar kind of prayer in item 10 also, Lord. I have been newly engaged. Today is my first day in getting the case.
No, that's okay, but
I'll be
renew the prayer when the matter is called.
my Lord. Worship.
Wait till the matter is called. We are not passing any adjournment orders today. On Tuesdays and Thursdays, we are not adjourning matters.
Ma'am, regarding item number 11, Milord. Person is expired,
Okay.
inform me.
What is your instructions then?
Then the person is expired, Milord. So nothing. No, not to proceed, not to proceed.
You take a considered decision because this will haunt you. Other persons will be.
Subsequent, the legal year. Then after some time we have to for it, I'll take it.
Item 10, 11.
11, Abdul Jalil.
Upon instructions. Mr. A. Rashid, learned counsel for the petitioner, submits that the petitioner has expired on.
The date I remember over phone,
Petitioner
Milord.
expired, however, it does not have the particulars. According to the magistrate's adjourned to enable the learned counsel for the petitioner to provide a copy of the death certificate for the record. List after 2 weeks. Oh, yes. Item 15, this is the matter before any other bench without one of us. Cares to Naji. Eight. Okay.
Item 1 for admission.
What is the best document you have to connect you to your projected parents, and what is the reason for delay?
I have explained
Para 12.
Yes, Lordship.
Could be a response.
What, 19, the order was passed in 20, and it is document of 21 of some hospital and doctor, some year 8 and all that doctor. But then again, 25, this matter was filed. No explanation to why they delay after 21, Lordship. And all along she knew that the proceeding was there, Lordship, and the copy was also applied only in 25. So it is a deliberate attempt, Lordship, not to come to the High Court. Now when the process has started off, picking them up and sending them to the detention center and holding camp, Lordship, so this petition has been filed as an afterthought, Lordship. Could have been filed after 21 also, but there's no explanation to that at all. Twenty-one to 20, 19 to 25, 5, 6, 7 years delay, Lordship, almost 7 years. COVID again, the COVID you can say.
किस बात पे कैसे हस्बैंड कैसे या पे कैसे किस बात पे
Trying to find the judgment of Karnataka Power Corporation, Lordship. It says that we did not know about the proceeding, the last.
No, not that. This petition is filed on 20 December. In paragraph 12, the statement is 21 December.
And even somewhere it is stated that she did not know about the opinion. And the petition came to know about the opinion only in the month of February 2025, paragraph 13, Lordship, page 12.
The,
Final outcome, she could not have taken
the
judgment.
advantage of having my esteemed sister here is just enormous. Come to page 26 of your brief.
Twenty-four, 9/18, Lordship.
Now, there's something wrong here. This evidence in chief is 24, 9/18. Page 32, oh, sorry, 33, 34. Page 34, the cross-examination is in 30 March 2018. It is predated. Cross-examination is predated. Now, hmm. Same. Now, thereafter, this 37, Muinuddin Ahmed, he was examined on 22/11/18. His cross-examination is 33, 2019, page 44. 33, 2018. In type copy, you have written 18, 19. It should be 18. 30 March 18. Again, predated. Why to keep a control as well? No, there's something wrong, Mrs. Verma. That's why we are making a mistake. Page 34, at the top, it is written 30 March 2018. Correct. Now come to the page 36. Now 33/19. Again, you see at page 44, 30 March 18.
Yes, Lordship.
Page 45, it is 33/19.
Mistake, Lordship.
No, we understand, but if you make a comment, then you will say that the Lordship is making comment against the officer without hearing him.
I have correctly pointed out these are.
No, there's another something. We'll see the order sheet. Now this page 48.
The order sheet, Lordship.
No, not this. The
The petition.
petition. Page 48. 6 June 2019 is the further cross of, we don't know what it is, cross or This is 6 June 2019. This is Gampura.
Yes.
Here the date is again 19 only.
6619.
Yes,
Now,
page 51.
page, yes. Now, page 54, 6 June 2019, PW4 was examined. Headmaster. So, even if you're, after your husband died, you proceeded with the case.
Yes.
You brought witnesses and examined them. So it's not open to you now to say that only for the purpose of filing a writ petition, your husband had expired.
No, madam, during the time of hearing, we stated during the time of hearing.
But you procured witness after the death of your husband.
Yes, some conversation.
Then
Madam. So for medical the case, madam. See, I think madam, good case, madam.
also got the hearing done. That is all post death of your husband. So it's not open to you to say that because your husband had expired, you are unable to take steps. You're not so much on the,
No, madam, the final judgment, madam.
pardon me?
Final judgment was not.
No, no, if the proceedings is in the absence of your husband, final judgment has to be in the absence of your husband.
That due to COVID, madam. After 1920 COVID comes, madam.
Pardon me? No, that's okay. 20 till 22, we excuse you. After that also, there's no explanation.
Yes.
You're not very strict during the COVID-19 period. Supreme Court had extended the period of limitation.
Should we also consider the medical case, madam? She could able
Okay.
to madam, establish the link.
Pardon me?
She established the link, madam. Headmaster was examined, madam. There is a certificate of register, madam. And with the register, madam. Yes, madam. Also, madam, girl is the land document. But the finding.
Please pass on the record. The record. Ms. Verma.
Okay, for delay in latches, I would like to rely on one of these judgments passed by Lordship WPC 2930 of 2025. Lordship has recently passed the judgment. We would be relying on that, Lordship. And on merit, Lordship, there is, the link has not been able to prove the school, the headmaster's certificate carries the state emblem and even the Gaubura certificate, so both are inadmissible in law. And the gift deed which was produced before the tribunal, after careful perusal, it was found that the registration was done only after the reference was filed, after the reference, registration of a reference. So that's an afterthought. That is at page 85, the third paragraph. Lodge. That was the linkage with his alignment. And the other document also, Lordship, her brother's sister's name does not figure anywhere else as stated in the evidence. But I don't see any information in the opinion passed by the member, Lordship. And the delay has not been explained properly, so Lordship, this judgment completely fits into this matter, Lordship.
The registration, you are referring to the cell deed.
Lordship, that is at page 85, Lordship.
Hmm?
Gift it.
Page,
I'm referring from the opinion, Lordship. Page
yes, page.
85. The second paragraph, the proceedings other linkage document is gift deed which is executed in between Hajira Khatun, Khudeja Khatun, about 5 names, which is executed on dated 36/2010 before the sub-registrar office, Naga. After careful perusal of this document, it is seen that the document is executed after the registration of a reference. So this document grave doubt about the genuineness. Which page?
85.
Yeah.
It was executed, man. And with it, page 70.
So reference was registered in Rocket 98.
These records again.
Hello. So far, I knew the ease of state employment, my lord. This petitioner is not the writer of that certificate, my lord. So how she will
We won't make a comment. You see, if the lawyers don't read the judgments of this court,
Yeah.
which were authored prior to this evidence being led, that a state emblem, use of state emblem is illegal, makes a document inadmissible in evidence. If the lawyers don't read the reported journals, we can't help it.
otherwise these two documents, my lord, duly put before the tribunal.
Pardon me?
These two documents were duly proved by the petitioner before the.
No, you see, it loses the evidence. It loses evidentiary value.
Lordship, any specific page Lordship wants to look at?
Just see the reference. No, it's in your top, where your hand is. Only there. Yes, just after that. Follow 2 pages and you'll find the reference. No, after the order sheet. You've got what you're trying to ask you. You see, there's this only 4 pages of reference, correct? There's nothing on record to show that the verification officer met the petitioner or anybody in the family, correct? Now this reference is of 98. Down below, look at the red ink. Registration of the reference before the tribunal. Down below, red ink is 2012. First page.
Yes, Lordship.
Correct. Now look at the first order sheet. No, first order sheet will be page 1. First order,
17.
17. Now, the tribunal says that the reference was registered. Registered before whom? Before the SP? In 98. Now, if this, if the proceedee is not asked any question, how can you say that she is aware of the reference against him, against her?
Lordship, I think he has been marked a D voter. I saw somewhere.
No, we understand. D voter is okay.
Yeah,
No,
I
no.
have to send it.
That's okay. D voter is there. The knowledge of being a D voter is different from the registration of a reference. Because you see, if there's a case against me, I must know it. And the proceeding will know about it. Only when somebody goes and asks him, makes a query. There's nothing on record
She
that.
did receive the notice and she did participate in the proceedings. Lordship.
No. She received notice in the proceeding and participated. But the tribunal is rejecting the sale deed on the ground that it has been registered after the registration of reference.
Yes.
Now we are on that. There is nothing on record to show that this, in course of the proceeding, she was quizzed by the police or the
Yeah, it's because this is the electoral roll thing. And the The election office sent it to the police on 94, 98 on top.
And that means the police mechanically, as a postman, made a reference to the tribunal. No, we understand. We are not questioning that. We are not questioning the procedure at all. But please tell us, how does the petitioner have the knowledge? So that you discard a document being a post-reference document.
Logic is handwriting below in the red pen. It is in the FT office, not in the police office, because
No, no,
Logic.
you are absolutely right.
Yes.
So
Because
it goes,
that's where it was marked there as their communication number in the year 2012.
2012.
Yes,
That means salary is of 2010.
because this reference is of 98. Lordship, the ERO document is not here, like it is here, Lordship. I'll just go through it. ERO document is of 97, 6/11/97. So 6/11/97, the ERO must have gone on this extensive door-to-door.
No, whatever they done there is very good. They did whatever they want to do.
Lordship.
You see, that is not the query.
Lordship's query is that the member has rejected the land document.
Land document
this
on the
post-
ground that it is post-reference document.
Yes.
Now, when a reference is made, maybe she is a D-voter, but she has no knowledge of a registration of a reference
But
before
she-
the
but
office
she
of the SP.
Submitted any document, that is why her reference went.
Who's asked her? Is there any record? I showed you the documents. Does anybody say that I went to her and no documents were served, given to us?
That was never written in the form, Lordship.
Then
The
there's no
ERO
presumption.
LVO must have gone.
Please read it. It's not there.
Yes, it is not there.
Then it's not there, it's not there.
And the person who went, his name is the verification officer. Chandra Hazarika is there. Lordship. Matita Yasini. No.
Nothing, it does not even say that we met her.
He says this format, it says, Lordship, as desired by you, I have made necessary verification in respect of Srimati Aheda Khatun by making an on-the-spot visit. My verification reveals the following particulars in her case: name, address, husband's name, and below serial 7 says name of state constituency does not arise, and other all are mostly blank.
Is it not false? You see, you say that she is a D-voter. The name of constituency does not arise.
In the police report, Lordship, from 7, which says here, does the person's name appear in the electoral rolls prepared prior to 25th day March 1971?
No,
If so, details no.
correct.
She's 42 in years at 2019. So her name and this reference is of 98. If we the back calculation also we do, maybe she was not eligible for voting. I think she's And does the person's name appear in any public record such as Panchayat, family register, refugees? No.
Are you aware, as per her evidence, what is the date of birth? As per the school certificate,
She left school Lordship when she was, I was just going through it now.
in the school certificate, you have the date of birth. Which page is your school certificate?
Yes. This is transfer certificate, page,
Hmm?
page 57. Madam.
57.
Yes.
31/7/1981.
Lordship, in her examination in chief, she writes 37 years. That is in 2019. 37.
Yes, is it? No? Because in most of the reference, when we find, is that very LVO, we will normally write that she could, the proceeding did not produce any document. That statement is also not here.
This is by the LVO lordship.
LVO,
Yes. And lordship, most of the times when the verification is done or when they are suspected to be illegal, they don't have documents with them. And they will never give the correct address, lordship. They will give the address of Borpeta,
Everything-
but the
everything
reference
accepted.
will be in Hojai because
everything
over a
accepted,
period of time, they keep on moving.
everything accepted. But that evidence is not here. In this case, there is no movement. They are in the same village.
The same village, and she was well aware of it because when he went for the on-spot verification, lordship,
Knowledge cannot be presumed.
lordship,
Knowledge cannot be presumed. Let
lordship,
us give a very horrible example. Now, today let us say the court misbehaves with you.
lordship court,
Let us assume for the time being today, the court misbehaves with you. Correct. In the entire corridor, we have gossip about what happened in the court today. Will it mean that all my other brothers and sisters or the Honorable Chief Justice will also have knowledge of what has transpired in court? No, knowledge cannot be presumed. If a complaint is made before the Honorable Chief Justice and say that this has happened, knowledge will derive from there. Presumption of knowledge, we don't know.
I get what lordship is coming to, but even if this argument we drop lordship, the delay and latches, they have not been able to give a proper explanation, lordship. That part still remains from 19 to 7 years, lordship.
Okay, we'll examine. Submissions of Ms. G. Uddin, I will transfer for the petitioner. Mr. M.R. Adhikari, and its CDC. It's A. Verma, and its medical DFT matters. Ms. Khan, on behalf of Ms. E. Barwa, standing counsel for the CI, Mr. P. Sharma, and the additional senior government advocate for the state respondents. Please come to that. Judgment result. I'm sorry, I have a very weak memory.
Okay, we would like to rely on minimum 80 and the other one, lordship. WPC 2930 of 2025, Muhammad Masjid Ali.
name is? What is the name of the
Mohammed Majid Ali,
Majid Ali? Majid.
Mazid, Lordship. Majid Ali. The case number is WPC 2930 of 2025. 30. 2025.
You have the date of disposal?
16/7/2025.
15/7.
2025, Lordship.
This is on what point?
Lordship, it's on delay in latches. And it's Lordship's judgment, Lordship said passes judgment, yes, Lord. It's on delay in latches, Lordship. Lordship, in detail, we would like to rely on Mrinmoy Maiti.
On
Mrinmoy Maiti, Lordship. Civil, it is to 2024 live law, SC 318. Paragraph 9, 10, and 11, Lordship.
okay.
Judgment reserved.
For orders, item 2 with item 3 and 4.
May it pleases your lordships. My lord, it's an ex parte order, lordship. And the process server report is at page 51, lordship.
This detention matters, we'll take it up all on 18th. The Advocate General is making his submissions on that day. We issue a short notice, Mr. Payeng. This is an application for bail.
Yes, Lordship.
Date on 18th. Mr. Pang, okay? Third, Mrs. D. Ghosh, I'm counsel for the petition, applicant, as well as the respondents. You should notice on this interlocutory application for bail, which is made returnable on 18/8/2025. Extra copies of this application be provided to the Grand Standing Council for the FP matters, report of the day. List of 18/8/2025.
Lordship, we may not be deported, Lordship. That order is not, I think it's not there in the main writ petition.
This is the ex-parte opinion of 2019.
Yes, Lordship, but notice was not served, Lordship. This is the reason I was pointing out on processor. Even the process server report says that return the notice unserved.
There is in the record.
Yeah, records are here, Lordship. Process server report, Lordship. On the down below, Lordship. Even a note also is there, Lordship. It says that the work has been completed long ago and the person concerned had left the site long ago in December 2016. And down it's written that return the notice unserved.
I think we have to set it aside. Does she?
51, but
I have annexed also this, page 51 is that notice.
No, see the original one. Has to be set aside. They're at the motion stage. Last page, backside. Absolutely last page. And then the order sheet, look at the order sheet, second page, first initial side. Yes, back page. No, before that, back page of the order sheet. Second page, second order sheet. Back page, no back page. No, that one, second, earlier page.
Yes, yes.
Yes. Notice duly served.
Yes, notice, as per 358, it is covered. Because, it is, your lordship may kindly see the notice once again. I would like to read out. Because
No, it
last-
must be hanged at the last place of residence. It could be hanged.
No, that's why, madam. The
But if it is-
Residence was there in the, residence was in the properties of this mallet, where they were working.
Yes.
Yes, that, there it is served, ma'am. Your lordship may kindly see the report. Report, my understanding is it is not taking the entire report. Last part of the report it is saying, madam. স্থানীয় কৰ্মচাৰীৰ পৰা সাক্ষী হিচাপে চহী লৈ নটিছখন মূল কপিটো মহামান্য আদালতলৈ ঘূৰাই পঠোৱা হ'ল। অৰিজিনেল কপি চেণ্টেক। অন্য কপিটো কোম্পানীৰ ৱালত লটকাই থৈ অহা হ'ল। ডেট হোৱাট হেজ টু বি চেণ্ট।
It is at
অন্য কপিটো কোম্পানীৰ ৱালত লটকাই থৈ অহা হ'ল। Where he works, madam, either in the residence or in the place where he works, there it is to be, the notice has to be served. He worked in that office. Notice was served in that office. It is their duty to inform before leaving that place, my lord. They did not inform that we are leaving this place, and it was their duty.
No.
No,
They are not, he is not aware of that a reference has been made against him. That I have also
to that, madam.
inquiry, but
Reference
with regard to his citizenship, he would have, and even I have checked the record, WT message was sent. If you, from his local verification officer, if you would have asked his
My lord,
permanent
we
address
run
also he has
run
given.
against a particular person, we have to go to Delhi, we have to go to Mumbai. Everywhere he will go, my lord, we will have to run against that, behind that one. Is it our duty?
His permanent address is given,
It is
lordship.
provided, my lord, in the rule itself, that they have to.
send the record.
Then a processor is wrong. He has stated return unserved.
No,
Then
it
he
is
should have-
process servers written.
Yes,
Let's
return
not
the
give
not-
you a proper manner. Let him
Return the
return-
notice unserved. It's written,
It is-
then
it
he
is
should
in
have
process
written.
servers report, last line, read the last line.
I have checked that. Then return the notice unserved. See, it's written here, return the
What is
notice.
there in the report,
That also, then he would have said, return the notice in a substituted manner. Then he has written, return the notice unserved. Contradictory statements.
they will not appear before the court, now they will claim that
They've appeared now.
after 3-4 years, 5-6 years.
People should be aware of the reference. They are not being informed that a reference has been made against them. Entire thing is that his permanent address is given there. If he would have been arrested from the notice, would have been easily served in his permanent address, lordship.
We are not satisfied, we are setting it aside. This is something which is impermissible. Had this happened in our judicial functioning
Yep.
of either the civil court or a court of criminal jurisdiction, we would have started a vigilance inquiry against the you see, page 7 is the reference. We send you again. Page 7. The Supreme Court Police, while making a reference and sending it for inquiry, gives two addresses. Correct?
Yes.
Now turn over the page. There's a verification report of two pages. You got it? No, after that, 1 or 2 pages. Yes. Yes, somewhere here. You got it?
Yes.
Now see the report. In 2015, when the inquiry was made by the inquiring officer, he is not there.
Yes.
No, the next, yes. The inquiry officer, he gives a note.
During inquiry.
Yes. So in 2015, when the inquiry was made, he is not there. And in the SP's what you call registration of reference, the two addresses are there. Now, why would the tribunal not issue a notice in the first address? Why second address? When everybody knows he is not there. It's not the case of the state that he gave one address and is absent. The SP knows two address. Second address in the inquiry time, he is not there in 2015. Why would the we'd be sending this in this address where he is not there? He's a laborer. statement of the two witnesses are taken. Witnesses say he's a laborer. If I know Mr. Pang is here before this court and I stealthily issue a notice at your home address, in the registration of address, two addresses were there. Why would no notice go there? And the tribunal knows it's a temporary address.
Yes, madam, here is address, madam. Definitely the address is there. In piece number 7.
And the report says that he is not there. The SPD, you see this process service report, right? In the left, process,
Left.
you know, in the last page, the process service report. Process server report says duly served. But when it is returned by the higher authority,
There
he
it
says
is
returned unserved,
Answer. The higher authority said answer.
unserved.
Process server report it is served, madam.
Yes.
In fact, my lord, his statement was also recorded in this place. madam.
No, we understand, but do you see the process, even the authority forwarding it knows it has not been served.
But that is true, my lord, that they could have served the original address also. Because
Original address is not given in the notice. That's the fault.
no, my lord, it is not that, my lord, it is true, my lord, that has to be served. Would have been served in the original address also. If it is not there in the present address. But it is also true, my lord, he has the knowledge. To have informed before leaving
Please
that
tell
place.
me, I am asking a very simple question. A permanent address and a temporary address is given.
Yes.
Why would the process be issued in the temporary address?
Permanent address, it could be served. Definitely, it could have been served. That is one aspect. My lord, my lord, law has said it was their duty to inform before leaving that place. That is also not informed by them. Because it is not that he didn't know the point.
That's why we are showing you the report. Even on the day of inquiry is not there.
Prior to that, my lord, this is of 16/12/2014. My lord, there was two inquiries. On the initial day, there was an inquiry. He was given 15 days time to produce the document. He left the place. Thereafter, he did not appear. He
No.
was given 15 days time. to
Please
report
tell
to-
me, is the conduct so bad that this proceeding gives the SP the correct address? Home address is given.
No, that was probably, my lord, here what he has said it. May I read the, my lord, please, but this is in the, my lord, address where the notice was effective. মোৰ নাম ও ঠিকনা বয়স আৰু ওপৰ লিখাৰ দৰে সত্য হয় মই পকা মিস্ত্ৰী লেবাৰ কৰো এই ফেক্টৰীত কাম কৰা 2 বছৰ হ'ল মই পঢ়া শুনা কৰা নাই মোৰ ঘৰত পৰিবাৰ মা দেউতা আছে গাঁৱত খেতি বাতি আছে মোৰ আজাৰা পুলিচে মোক নাগৰিকত্বৰ প্ৰমাণ বিচৰাত দেখুৱাব পৰা নাই পুলিচক মই 25 দিনৰ সময় বিচাৰো পুলিচে মোক 15 দিনৰ ভিতৰত মোৰ নগদ পত্ৰ অনাৰ বাবে কয় মোৰ বক্তব্য ইমানে that was his description and this he has given his some impression mother and address is given in the present that was his answer but then he did not appear then this next one of the I don't know, Melody has where from the SP has got this present at permanent address. But the next Melody form has stayed unfilled. The address is here definitely could have been served. But it was their duty, my lord, to inform the officer concerned before leaving that place. But when he was caught, he was given time to submit documents within 15 days.
I have given my permanent address. My humble submission is that if I have any intention, then I won't have given my permanent address. I have given my permanent address, where from I am being arrested.
Of the Constitution of India, on the petitioner, namely so and so, has said the ex-parte opinion dated 30/3/2019, page 23. As by so and so in so and so, they were declaring the petitioner to be a tribunal has concluded that that the petitioner is not born and brought up through genuine Indian parents in Indian soil, and he failed to prove that he is not a foreigner. And accordingly, it was held that the petitioner has entered into the state after 25/3/1971. Next para. It is projected in this writ petition that the petitioner was not aware of the proceedings, as no notice of the tribunal was served. So moreover, comment is also projected in this writ petition that on 26/5/2025, petitioner was taken into custody And he's presently at where?
Matia lordship.
Is presently lodged in the transit camp Matia Golpara. So therefore, the affidavit in support of the writ petition is sworn by Bahajuddin, Bahaj, Bahajuddin, who claims to be the younger brother of the petitioner. Next paragraph. The learned standing counsel for the FT matters has vehemently supported the ex-parte opinion rendered against the petitioner, and he has submitted that as per the process server's report, in the presence of two witnesses, the notice of the tribunal was pasted in the wall of the company where the petitioner is serving, was serving, and therefore he has submitted that the notice was duly served in accordance with the provisions of paragraph 3 5F of the foreigners within bracket tribunals bracket close order, 1964. It is further submitted that as per the requirement of law, upon a reference being registered against a proceeding, in the event the address of the proceeding is changed or he is shifted to another place, it was his duty to inform the office of the superintendent of police within bracket border about the change of address. Accordingly, it is submitted that is the current address of the petitioner was not disclosed, notice is deemed to be duly served, and therefore the ex-parte opinion ought not to be interfered with. After a lapse of about 6 years from the date of rendition of the opinion. Next paragraph. On a perusal of the records, it is seen that that white memo dated 19/1/2015, the Deputy Commissioner of Police within bracket B border, bracket was Guwahati, had directed the concerned sub-inspector within bracket border to make an inquiry under the Foreigners Act, 1946 and submit his findings. And in the name and particulars of the suspected foreigner, the permanent address of the petitioner at village Bheragaon, Bheragaon, PS Borpeta, PS and district Borpeta, Assam was disclosed, and the present address was disclosed as care of Sri Subrata, 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 or HRE, son of late Bani Prasad, Bani Prasad, or HRE, village Rajnigandha, Rajani, next word Gandha, Gandha, factory, comma, SOS road, PS Hazra is recorded. Full stop. The said inquiry was re-endorsed to another sub-inspector within bracket border under Hazra police station. Full stop. The travelers records. Also reveal that when the concerned sub-inspector of police had visited the site of temporary address of the petitioner, the two witnesses examined had disclosed that the petitioner had gone to his home and then did not return. By the inquiry officer, we were informed that two witnesses examined by the inquiry officer on 16/5/2015 had informed that about a month ago the petitioner has left their factory and did not come back. And accordingly, the information was returned by the inquiry officer to the competent authority that during inquiry, it appears to him in a prima facie manner that the suspect could not be traced out. Nobody knows his whereabouts and is untraced. And accordingly, they said, no, this report dated 16/5/2015. Full stop. Accordingly, on return of the said report by an endorsement dated 29/6/2015, the reference was forwarded to the Foreigners Tribunal at Kamrup Metro for opinion. Full stop. Next para. The reference was registered with two addresses of the petitioner, one at village Bheragaon under PSN district Borpeta, and the second address was the present address of Rajnigandha factory at SOS Road under police station Azura in the district of Kamrup Metro. Full stop. The records of the tribunal further reveals that notice was issued only in the current address of the petitioner at Rajnigandha factory at SOS Road under PS Hazira, but no summons, but no notice appears to have been issued at the permanent address of the petitioner. Next para. The verification report of the inquiry officer, who is a sub-inspector of police within bracket border, clearly discloses that during inquiry, the petitioner was not at the temporary address. First of the witnesses examined had also stated that the petitioner had left that place. First of these materials were available before the learned tribunal, despite which notice of the proceedings was issued at the temporary address without making any attempt to make service of the notice to the permanent address which is available on record. Next para, we also notice that while the process server's report clearly discloses that the notice was duly served by pasting it in the wall of the factory, but while the notice was returned by the concerned authority of the Azura police station, an endorsement was made to the effect, to the following effect, dash, inward commas, returned the notice unserved. Full stop. Therefore, notwithstanding that the process server gave a report which is in consonance with the due compliance of paragraph 3(5)(f) of the ordinance within bracket tribunals, bracket close order, 1964, yet the authority who is returning the notice has made a clear endorsement to the effect that notice is being returned unserved. Next para. Under such circumstances, when there is no order of the learned tribunal in the record as to why issuance of notice on the permanent address was dispensed with, making an attempt to serve notice at the temporary address where the petitioner was not available when the inquiry was being made. Vitiates the issuance and service of process at the temporary address without any attempt being made by the learned tribunal to serve process at the permanent address. Next para, accordingly, for non-service of notice at the permanent place of residence of the petitioner, the ex-parte opinion dated 30/9/2019 is liable to be interfered with.
They like to show your lordship, my lord, exactly what is there in the provision in the Foreigners Penal Order 1964. I have seen, my lord. 5B has not nowhere said that 5B, the notice has to be served. It is clear, man. The lordship may kindly go through once for the moment. 5B.
3,
Because where notice is to be served, 3
yes,
5A. This is, my lord, something lordship may have to look, my lord. 5A, the notice shall be served at the address where the proceedee last reside or reportedly reside or works for when, and in case of change of places of residence, which has been duly intimated in writing to the investigating agency by the alleged person, it shall be served at such same address by the foreigner's bill. This must not. There is no provision for that this has to be served in the original address where he is residing. This provision is not there. I've seen the matter. It is clear.
Fine.
Shall be served at the address where the proceeding last written.
you also say the learned counsel for the FT matters has also referred to the provisions of section of order of paragraph 5 within bracket A of the Foreigners Tribunal's orders or order, 1964. And it is submitted that there's no requirement of notice to be served at the permanent address of the proceedee, as the law mandates that the notice is required to be served at the last address where the proceedee reportedly resided or works for gain. Then the findings which I have said, before you said that the notice is vitiated, there you say,
It is because, my lord, the
as the learned standing counsel for the FT matters has referred to the provisions of paragraph 5, 35A, or the same is quoted below. 35A to be quoted. Next paragraph.
my lord, the underlying principle for this reason behind this, my lord, because the person who may come from, my lord, is Pakistan also directly. He may reside in somewhere temporary. His permanent address may not be, my lord, found. So it is not possible to serve in the permanent address. That's why this provision is met. The other, unlike, my lord, other CPC or JPC, it is not that the notice has to be served in the permanent. Because his permanent address may not be known to be, my lord. He may reside temporarily in the here and for his personal gain, works for personal gain. That's why this provision is.
in this regard, there are two aspects of the matter. Full stop. Firstly, comma, that while making a reference, the competent authority has provided two addresses of the petitioner. The notice of the tribunal was issued in the present address, which is the last address where the petitioner was residing. Stop. However, comma, as already referred above, comma, at the time when the inquiry was being made, the petitioner was not found available there. Full stop. The two witnesses examined had stated that the petitioner was working as a laborer. And in the process service report, the factory where the petitioner was working had made an endorsement to the effect that the work has been completed long ago and the person concerned has left the site long ago in December 2016. Full stop. Therefore, it's not a case where the petitioner was found at the place of last residence when the inquiry was being made. Full stop. On the other hand, in paragraph 3 of the writ petition, the petitioner has made a categorical statement that he was arrested. Or taken into custody on 26/5/2025 from his house at village Bheragaon under Borpeta police station and district, and under police station Borpeta and police station and district Borpeta. Full stop. While issuing process, the learned tribunal has not recorded the reasons why process was not issued at the first address of village Bheragaon, PS and district Borpeta, as provided in the reference. Therefore, comma, court is of the considered opinion that the learned tribunal, comma, with full knowledge that the petitioner is not residing in the place where the process is being served, comma, issued process in the last known address and last one is a full stop. In absence of any order by the learned tribunal, it cannot be said that the tribunal was not aware of the two addresses and there is no order by the tribunal why the notice should not be sent at the first address. Full stop. Moreover, comma, in the opinion dated 30/9/2019, comma, a specific observation has been made by the learned tribunal, comma, whereby it is recorded that the Deputy Commissioner of Police, comma, Kamrup Metro, comma, Guwahati, had expressed doubt about the nationality of the petitioner, namely Mohammad Wajuddin, Wajuddin, comma, son of Mohammad MD, Javed, Javed, Javed Ali, comma, village Bheragaon, PS Borpeta, district Borpeta, Assam, presently residing at care of so-and-so, as care of the Rajnigandha factory at Hazra, district Kamrup. Full stop. It is not the case of the state that the permanent address given by the petitioner was false. Therefore, comma, as two addresses were available before the learned tribunal, comma, the non-issuance of process at both the addresses, comma, as already referred herein before, comma, is found to be vitiated the proper service. This will be same. Next, at the end, you say, resultantly, comma, the impugn opinion, ex-parte opinion dated 30/9/2019, passed by so-and-so in so-and-so, that is page 23, is hereby set aside. Full stop. The matter is remanded for a fresh opinion by the learned member, Foreigners Tribunal, 4th, Kamrup Metro, Guwahati. Next para. As there is already a reference made against the petitioner, it is provided that the family members of the petitioner shall appear before the office of the Deputy Commissioner of Police, Kamrup Metro, Guwahati, and furnish a bail bond or rupees 5,000 with two surety of like amount to the two solvent surety of like amount to the satisfaction of the said authority. This is ABC. B, before releasing the applicant on bail, the Superintendent of Police, Borpeta, shall obtain the biometrics of the iris of both eyes and the fingerprints of both hands and photographs of the applicant. It will be petitioner. And C, the said authority shall also obtain necessary information and documentation as required under the rules from the petitioner for securing his appearance before the learned tribunal. Next para. Thereafter, the Superintendent of Police, Borpeta, shall take appropriate steps to have the petitioner released from the transit camp, Mati at Gwalpara, within, this is 11th. You'll have to wait some time because this is Independence Day. They will not be going anywhere. SP office will not do anything but for maintaining law and order duty. So it will be released by 19th of August. To take steps for release of the of the petitioner within 19/8/2025, 19/8/25, most of the this is because of the this is by taking into account the law or duty which the said authority has to take into consideration because of the because of the ensuing Independence Day celebrations. Next para. Or as a condition of bail, the petitioner is directed to appear before the learned member, foreigners tribunal, 4th Kamrup Metro, Guwahati, in connection with FT case number so and so, page 23, within 22/9/2025, and file his written statement and produce all the documents in support of his written statement. And thereafter, the learned tribunal will fix a date for evidence of the petitioner. Next, it is made clear that if the petitioner fails to appear within the before the learned tribunal within the time allowed, it could be open to the said learned tribunal to treat the petitioner as absent on call and pass an appropriate order by treating the petitioner as absent on call. In this IA, you say that all sides are represented in view of order passed in connected WPC 3767 of 2025, comma, no order is required to be passed in this interrogatory application. Accordingly, this interrogatory application stands closed. And in the main case, it was also right. Mr. Payang, this record is produced by you. We are returning it to you. Let me just say the records of the FT case number 1435 of 2017 was produced by the learned standing counsel for the FT matters pursuant to request made by the order dated 6/6/2025. Accordingly, the records are handed over to the learned to Mr. J. Payang, learned standing counsel for the FT matters for onward return to the said learned tribunal. This is over.
One thing was not, one, it was feasible, but it was not the whereabouts of the petitioner.
Yes.
Thereafter, he was allowed, the petitioner, in that case, petitioner was allowed to meet the, decision. But he was not allowed, and so the order, interim order was being challenged by the brother.
In both this, other petitions, 3050 and 3349, you see that also the represented, Mrs. D. Ghosh, learned counsel for the petitioner, submits that this writ petition has become infructuous as the declared foreign national, namely Wajuddin, has already sealed the impugned opinion by filing WPC 3767 of 2025. Next, but accordingly, this petition stands post, having been rendered infructuous. Just record the presence of all, because it will be disposable. Record their presence. That's so.
What is the order to 33 is that.
It is, he'll get it because you have given the page number. Just see the page number. I mean, you know.
For all his bond.
Not the forfeited.
Not forfeit.
Acha. Oh, I'm sorry. That conditions will be on Deputy Commissioner of Police, Border, Kamrup Metro, Guwahati. These three conditions were there, no? Okay.
And I think he'll appear on 30th, because he released by next week. So he time and then consult on 30th. He may appear earlier on 22nd, but for WS, it is September, I think.
September, we are giving September.
September.
You want to appear early?
Yeah, that was.
Okay. Okay. We'll continue post lunch because in 1 minute, nothing can happen. That is the problem with my voice is over for the time being. Is now audible? If the voice is missing, then it's not good. No, it's no, it's good that you have pointed out. We appreciate that. Yes, item 5. Yes, Mr. Sharma, you need the records? Hmm? Yes. No, because obviously there is no date fixed.
Yes, Lord.
Party is not expected to take any steps.
Yes, it may get this to Lordship, but Lordship, not a single petition has been filed or his,
No, if there is no date,
yes,
if the matter is not taken up on a particular date, what is the requirement of filing a petition? Mr. Sharma, this is one place where I have never went.
Lordship.
I have never been to this place, these tribunals. Please tell me, what is the procedure? They have a court diary or the case diary? If you go to a trial court here, you have a case diary and you have a court diary.
Lordship.
Is diaries of such nature maintained in the foreigners tribunal?
Yes,
I think Lordship maintained.
yes, Lordship.
Maintains.
Maintained. Oh. वो जो रजिस्टर में डेट लिखता है नेक्स्ट डेट लिखता है they inform us that is that register that to be mentioned. Because we go there not to hear. It's an old matter, no, so whether that point of view that
Our learned counsel, Ms. D. Booth, for the petitioner, comma. With is submitted on behalf of the petitioner. Procedural, then, the petitioner he had received the notice according to you. The where is your ground? In which paragraph? Okay, it is submitted on behalf of the petitioner that he had received the notice and he appeared before the Learned Furnace Tribunal number 4, Kamrup Metro on 12/11/2015. Personally, without engaging any counsel and inquired about the case. To stop, he was informed that a fresh notice would be issued to him and then he would have to appear. But he, full stop. However, he did not receive any notice before the, any notice to appear before the tribunal. And he is aggrieved by the ex-parte order against him, declaring him to be a foreigner post 1971 stream. Full stop. The Annexure 2 series of the petition are the orders passed by the tribunal on 16/10/2015, 3/10/2018, 5/10/2018, and 10/10/2018, and the final order on 26/10/2018. Full stop. It is submitted that the Annexure 2 series, in the Annexure 2 series, the order dated 3/10/2018 clearly reflects that after a gap of 3 years, the case was taken up by the Learned Tribunal. To stop. It was observed by the tribunal that dated 3/10/2018 was filed by the Learned KDP, stating therein that the reference may proceed ex parte as against the proceeding, that the notice was duly served on way back on 10/11/2015. Although the reference was fixed on 12/11/2015, no order was passed after 12/11/2015. It was observed by the tribunal that as the proceeding had received the notice and did not appear before the tribunal, the case was fixed for necessary order to stop. Thereafter, the Learned Tribunal decided to proceed ex parte against the petitioner by the order dated 5/10/2018. The final order, ex parte order, was passed on 26/10/2018. the learned standing counsel, standing FT matters, Mr. G. Sharma. FTM,
Border method.
border matter, Mr. G. Sharma has submitted that then as the petitioner had received the notice, the petitioner had to appear before the tribunal. The petitioner also have appeared before the tribunal and contest the proceeding. To rebut that he is not a foreigner, but the bona fide citizen of India, full stop. As the petitioner failed to appear, the petitioner deliberately did not appear before the tribunal, and thus this case proceeded as party against it. Therefore, the order was correctly passed by the tribunal, and no interference is required. I've considered the submissions at the bar. So, it would be accurate that after the order dated 16/10/2015 was passed, comma, the record was not put up before the tribunal. On 12/11/2015, on the date fixed for service report. Thereafter, after a span of 3 years, the record was put up on account of a petition dated 3/10/2018, being filed by the learned AGP. So, the order on order on service report was passed after a span of 3 years, that is on 3/10/2018. So it cannot be ruled out that the petitioner did not have been aware of the proceeding as due to the owing to the as the proceeding was not being taken up on the next date fixed for appearance, and thereafter the proceeding was taken up after a prolonged gap of three years. After considering the conduct in which this case was being proceeded upon, this court is of the opinion that an opportunity may be accorded to the petitioner to place his case before the learned tribunal. Good job. The latches, the delay and latches of the the apathy of the office is taken into consideration, and thereby the impugned order, ex-parte order dated 26/10/2018 is set aside, affording an opportunity to the petitioner to appear before the tribunal within 3 months. 1 month. 1 month. And submit his written statement. You are in detention, something.
He is in detention. This is the reason I he was arrested on 26/5. PCP border, Kamrupi. Kamrupi border.
If your lordship thinks with lot, some time limit may be fixed for disposal, 2015 reference code.
May I submit in that perspective? Because there will be land documents. Suppose I have taken step and again the authorities did not turn up. So if it's a time frame, it will be difficult, but as expeditiously as possible. We won't take,
Every endeavor? Every endeavor.
yeah, and endeavor may be made to dispose of the matter as soon as possible. But if we see the reference also. Yes, doctor. If it's not possible, sometimes it's not possible, doctor, because dealing with the cases in the tribunal, out of my experience, I'm saying, doctor. So sometimes it may be possible within 3 months, sometimes it may not be possible.
You are required to file a written statement without,
Yeah.
you have to take steps. If steps doesn't
That's
come,
subject lot.
if step doesn't come,
1998 reference, now notices are being sent. So gap of so long.
That's
So
okay, but
those aspects are
2000
also there,
this is
not in
2000
this case, but in other cases.
the 2018 matter, we have to
Yeah.
be sure that preferably means, okay, they have some leeway to extend.
After that. Yeah. April. Can be kept the effort to dispose of the petition within 3 months.
Yes.
From the date,
Certificate.
from the date of, hearing. Okay, from the date of appeal. And every endeavor, yes. That there may be relaxation that
Because if land documents, then we have seen that sometimes they don't turn up on the date, when the date was fixed. So then again, we have to take steps. So dates.
this is nothing but to expedite the
Yes,
matter, as it is an
definitely.
old
It will
pending.
be our endeavor as a council of also to dispose, to take every endeavor to dispose of the case.
And when the trial court record,
Date of appearance lot. Lot, I could.
then record to be.
Date of appearance.
25th of. I think.
On DNA. Oh. Registry. Yes, lot. So registry. And.
appearance date 25th of September. The last date was 22, so this one make it 25th. Because since Kamruk Metro, we will assist so 25th will be better for them. So we'll file written statement on that day. Then 24th. Two written statement has to be filed in the same day, so it might be different. Earlier case was 22nd of September. It is for our convenience. Deep leave time.
Item 6 for hearing.
Please, please, please. As per order. Effect 12/2/20. As per inquiry proceeding, he declares,
Lordship, this matter may become up after full.
my lord. It is also a ex-parte order. As per inquiry proceeding, my lord. Report, I am reported as Indian bank. My lord, kindly see the case 49 and 51. But 49 and 51.
Because Lordship, on earlier occasion, I am speaking Lordship, some
And it is serious matter, it is the case is 2018. 2018. Yes, the petitioner has been deprived of the right of voting. My lord, the petitioner 49 and 51.
Just a moment, we are considering the prayer of adjournment by the standing council for the FT matters. Just a moment.
14 amendment. My father's name is
অলপ বকিব কৈছে।
my lord, petitioners.
No, Lordship. Not like that, Lordship. Not claiming citizenship under the Lordship. Minotibala Devnath. Minotibala Devnath, Lordship. Mhm. Lordship can apply Lordship and he can approach to appropriate authority Lordship. Lordship.
Hang on. Allow me.
Dada.
The petitioner till now, like, till now, it's about 68 years. So he may be more, he would be more. Otherwise, my demand ticket. I prove that I am citizen of it.
Explain everything to on everybody on earth, but we have difficulty in communicating with them. That's the last. Okay, we adjourn the adjournment. We fix it, take it up after 2 weeks.
Why not? Then
We take it up after 2 weeks. Give a date after 2 weeks. Both sides are represented on the prayer made by Mr. G. Sharma and his standing counsel for the FT matters. On the matter stands adjourned today. List on 26/8.
Item 7 for hearing.
There is no representation from the petitioner. The matter was previously listed on 29/2024 and on 23/7/2025. However, the petitioner remained unrepresented. So accordingly, in the order dated 23/7/2025, it has been recorded that if the petitioner remains unrepresented on the next date of listing, the court would make an endeavor to dispose of the matter on the basis of materials available on record. Follow. List on, make it next week. 26/8/2025.
Item 8 for hearing.
Apart from age variance, the certificate by the Gampur and Gampachar is not proved. So therefore, there is a gap. We don't find anything to connect you. But that is at the age of 37 years with a different name. Here you see, you are not Fulema Khatun. You are Kulekha Begum. No, but we don't know. You see, in your written statement, you have not stated anything. Pardon me, grandfather and grandfather's name? Which pages are the exhibited documents? Exhibit A is voter list of 1966 page. Who are these persons? This is exhibit A.
Exhibit one.
In page 16, who are they? Abdul Noor, who is he? And the second one? Stepmother. Yes. 1985 voter list. Who are they? It's not exhibited. That's why we were able to track it. Okay. Because you had exhibited 89. Who are these 3 persons? Page 22. Ulekha Begum, who is she? And who is the third person? Manwara? This way, sir. Okay.
Other thing is that believe it is the only for the very much more. And if we practically conduct everything, there was an order to purchase it. Telling the that father then after that fact we want to be
We are quite confused. Page 43, you see the evidence is there. Exhibit 5 is the Jamadi member, father's name and brother's name appear. Uncle is not there. In our evidence. Forty-one eleven. Where is this exhibit 4, which page? 24. In this Jamandi, your father's name is also not there. Serial number 4. Mohammed A. Noor. This is father. So Yes, Mr. Sharma,
Yes, Lordship.
you have anything more to say, Mr. De?
Lordship,
Because we are not still satisfied with the family which
Yes.
you are projecting.
each and every document, Lordship, there is a discrepancy, and Lordship, in respect of name as well as in respect of age also, Lordship. And Lordship, there is a specific statement in the written statement, Lordship, is page 38. No, page 38, Lordship.
For other matters, we don't think we will have time to take it up because 350 will be rising. Other matters, we may not have time to take it up. It has to be adjourned because we will not have time to take it up. It will be adjourned by default.
Lordship, in vernacular, Lordship,
Page,
page 38, Lordship. So, paragraph number 8, Lordship, in vernacular, it was a specific statement, Lordship. প্রতিপক্ষর ককা দেউতাৰ নাম মৃত আব্দুল মিয়া আৰু আইতাৰ নাম আকলিমা বিবি। Lordship,
page 38 para.
para 8, Lordship, vernacular.
Yes.
And
দেউতাৰ নাম মৃত আব্দুল মিয়া আৰু আইতাৰ নাম আকলিমা
Aklima
বিবি।
And in this written statement, nowhere proceeding has stated that Lordship, he is Abdul Mia and Abdul Mia are same in one person, Lordship. And subsequently in the evidence, Lordship, he said that his grandfather's name is Abdul Mia, Lordship. And Lordship, regarding that, Lordship, law has already settled by this honorable court, Lordship, that proceeding cannot go beyond pleading, Lordship. Para 25 of Rosminara Begum's case, Lordship, 2017 4 GLT 346. Para 25, I am reading, Lordship. Written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal, keeping in mind the mandate of Section 9 of the Foreigners Act 1946. It is incumbent upon the proceeding to disclose at the first instance itself in his written statement all the relevant facts, especially within his knowledge, having a material bearing on his claim to citizenship of India. Material facts stated in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. It is also tried that a party cannot reverse beyond pleadings made in the written statement. So, Lordship, regarding that, Lordship, law has already settled, Lordship, and so many decisions has been passed by the honorable court in the light of this proposition, Lordship. And
Please give this name again, citation.
2017 4 GLT 346, para 25.
2017 4 GLT page
346,
326,
346, 2017
346.
4 GLT
Para?
346, para 25.
And the name of the party is?
Rosminara Begum. RASHMINARA. Rosminara BGUM.
Yes.
And Lordship, in the light of this proposition, Lordship, so many judgment has been passed by this honorable court. And Lordship, after 1970, Lordship, each and every voter list, Lordship, discrepancies found, Lordship.
And all these things has been discussed in the impugned opinion, Lordship, in page 52, Lordship. Exhibit third para, Lordship, Exhibit 1 and 2 are the voter certified copies of 1966 and 17, where as per OP, the names of office fathers and stepmothers are enlisted being the residents of village Saran PS Murajar under 93 number Huzai LSE. Office father appears as Abdul Nur, son of Haji Aklu, aged 32 years and 36 years, whereas DW's in their deposition named Pope's grandfather as Aklu Mia. Now Haji Aklu and Aklu Mia cannot be presumed to be the same person without any explanation from the office side. Even if we consider it to be true, then who is Abdul Nur, son of Aklu Mia, with 40 years in Exhibit 3, 1989 voter list, who should be 55 years in terms of Exhibit 2, 1970, and likewise in Exhibit 4, 1997, with 50 years in place of 63 years. Discrepancies here and there may be understood, but such huge variation in the age of the office father cannot be overlooked, creating certainly some doubt about the actual identity of the person concerned so far as the office citizenship status is concerned. That apart, Kulema Khatun mother appears for the first time at the age of 37 years in 1989, and that too with totally different name, Kulekha Begum, again in 1997 as Kulema De. Lordship, this was clearly discussed, Lordship, and Exhibit 5 and 7, Lordship, 5 to 7. Are the copy of the Jamabandi, including the names of office mother with other members of the family as part after granting mutation on 31/12/2015. A land document marked after 1966/71 and 2 certificates in the name of Monwara Begum dated 22/4/2015 and 16/2/2019 by the concerned Gao Panchayat and government Gaubra. But it is right, mere production and exhibition of documents are not enough, and the contents of it must be proved to establish the truthfulness thereof. As such, no reliance can be proved on Exhibit 5 to 7. And Lordship, here in this case, Lordship, no, only link certificate is, Lordship, page 31. Munwar Saharan Muktab school certificate, school transfer certificate. It was, he left the school in the year of 1985, and this certificate was issued in the year of 2018. Then Lordship, next link certificate is Gaubra certificate, Lordship. It was also not proved. And Lordship, last link certificate is the Gao Panchayat certificate, and where Lordship, at the top of the certificate, Lordship, government of Assam as well as Lordship state emblem was embossed, Lordship. And Lordship, regarding that, Lordship, law has settled, Lordship, I'm going to rely on a decision of this honorable court. In WBC 7756 of 2016, Lordship, Deja Khatun. WBC 7756
Please
of
give the name again.
KHUDEJA. KHATOON.
KHU
DEJA.
Shakudeja Begum.
Khatun, KHATOON.
WBD 77 of
7756 of 2016
775.
and decided on 26/4/2018.
Relating to
Relating to Lordship, all the three issues as covered by this judgment, Lordship, regarding Gaubra certificate as well as school certificate as well as Gao Panchayat certificate, Lordship. from para 12 to
The date of judgment is 25.
date of judgment is 26/4/2018.
Yes.
Yes. From para 12, I am reading lordship.
Para,
Para 12.
what is the proposition here?
Here lordship, belated issuance of school certificate as well as lordship, embossing state emblem at the top of the school certificate lordship. This was, this cannot be accepted by the tribunal lordship. Lordship made it lordship, and lordship regarding lordship in Gaon Panchayat certificate lordship, they cannot emboss the letterhead, that is lordship government of Assam lordship. That was also embossed or clarified lordship. May, if
Not you can't just give the paragraphs.
12,
You have said paragraph 12.
12, 13, 14, 15, 15.1, 16, 16 lordship. Paragraph 12 to 16 lordship. All the issues is covered lordship by this judgment. And lordship, if proceeding cannot able to establish this link which is projected further lordship, so lordship may not entertain this writ petition lordship. And lordship, opinion, lordship, after reading lordship, I could find that lordship, there is no infirmity in the opinion passed by the learned tribunal lordship. That's all lordship.
And you says they not counsel for the petition.
Subsequent para is relying on both of the where the substantial thing that actually 89 and 97. It means the grandmother has actually my bishop. That's not the Gamma value. One aspect of it, if there is any doubt with regard to the person being the same or not, different voters list. That kind of is the, I want to track on the order of the committee.
Yes.
If Abdul must be provided almost that I have video transparency view is on the structurally action we can I think what is that is structurally
Accordingly, matter is important back to the response to the open department to make their own verification, whether it be 2% or 1%. Accordingly, starting the report which will get given. Respondents may also verify whether Dinatali, Mutali of the thousand village, but in Dinatali, Mutali of the voters of Son of Abdul Matlib of the voters list of 1959 of village anybody are one of the same person, or we submit the report to the division. Upon undertaking the efficient exercise, the reason order to be passed. That they arrive from the country. However, to have the budget back for everybody from both the that is not inquiry by the respondent. And in this case, I appear I don't have when it was demanded that it was before so that we in this case, also the primary doubt is that the person Abdul factor discrepancies are much lesser in this case. The village is the same, the person Abdul knows, Abdul knows of 1989 and Abdul knows of 1956 and 70 are the same. The father is the grandfather is the same.
Lordship, one important aspect of it is a lordship 1966 and 1970 is with a lordship. After that lordship, there is a lack of continuity up to 1985 lordship. As per section, not the
89.
then lordship, then up to 89 lordship. There is a lack of continuity and lordship after 1989 lordship, these discrepancies are
Not what can
errors lordship. And
But this, as the legal counsel for the petitioner also heard all the respondents are there. Arguments concluded, judgment is out.
So it's not a faculty that are the actual